illegal versus legal reasons to deduct wages from employees. This is an area where so many employers can really get themselves in trouble. You might be really well-intentioned, and maybe you're just setting up a deduction for a trip that everyone's taking together, or maybe a birthday or a Christmas club. Well-intentioned, there are some consequences we need to unpack and understand how to do those things right. But more importantly, so many employers get themselves in hot water in this area because of an employee leaving for not good reasons. Maybe it's unfavorable terms, whether you fired them, they quit, and they owe you equipment, they owe you work effort, they owe whatever, and employers could really get themselves in hot water, whether they're trying to do the right thing or even just grab their pound of flesh out of this thing if you do it wrong. So really, really important topic. All entrepreneurs, all small business owners really need to understand this, because this is probably one of the biggest areas where employers can get themselves in legal hot water. So my guest today, Brian Shenker, who's an attorney at Long Island, New York office of Jackson Lewis. Brian's practice focuses on representing employers in a wide range of workplace matters, as well as preventative advice and counseling. Brian has extensive experience defending class and collective action lawsuits under federal and state wage and hour laws. He has successfully defended wage and hour audits conducted by the U.S. and New York State Departments of Labor. And Brian regularly handles cases before courts and administrative agencies involving claims of discrimination, sexual harassment, and retaliation. Welcome back to the show, Brian.
Thanks for having me, Mike.
All right, so let's do, here's how I want to construct today. I want first explain kind of the consequences of not doing this very simple thing right. And then I think if I have it right, there's more technically, but there's really two big federal laws that kind of govern this area. I want to talk about what those are. And then really let's make this as practical as we can, use case by use case. When this happens, what can we do, can't we do? When this happens, what can we do, can't we do? So let's just start out. And we don't want to unduly scare anybody, but set expectations. What bad thing happens if you wrongly deduct wages from employees?
Yeah. So the repercussions can be pretty severe. So when you're talking about non-exempt hourly employees, if we have improper deductions, number one, you may then need to pay back those improper deductions plus penalties. But it can also lead to issues of potentially unpaid minimum wage, unpaid overtime. And so we get into those other unpaid wage issues under the FLSA and the various state laws, which have liquidated damages, attorney's fees. And similarly for your exempt employees, as we'll get into, those salaried employees, improper deductions can destroy their exemption from overtime, and can actually even go so far as destroying the exemptions for other employees in that classification. So these are often things that an employer doesn't think are such big issues, but they can have wide-ranging effects. And as you mentioned too, one area that we'll discuss is deductions made at the time of termination, and that's something where I always try to guide employers away from making deductions certainly that are improper, but even considering proper deductions at the time of termination, because that can lead to an employee, having a bad taste in their mouth, going to see an attorney or a Department of Labor, and asserting a claim that was really caused by, the company, like you said, wanting their pound of flesh. So maybe it was a $200 or $300 issue they deducted, and now they get themselves into a wage and hour audit.
And even if it's not a pound of flesh, maybe the employer thinks, hey, that's only a $200 piece of equipment to you. That's $200 out of my pocket. That's a lot of money to me. Mm-hmm. It's not a pound of flesh. I think it's simply fair, but the aggrieved employee perceives that, they're just trying to get their pound of flesh. And whether they're right or whether they're wrong, that's the trigger event. That's the hook to all of a sudden initiate action.
Yeah, exactly. And we'll talk about how to make these deductions, because sometimes a deduction might be permissible, but if done in a certain way or, given, with a written notice or, subject to a cap. And if, an employer, isn't aware of those and, does an otherwise permissible deduction, but say in the wrong amount, too high an amount, it's just, it can be just as tough consequences there. So, it's very important. There's, the federal laws we'll discuss, and then, state laws here. So there's a lot of things for employers to look at. Don't just assume that, the federal law doesn't say anything about this. I'm good. This is an area where, different states adopt different policies concerning different types of deductions. So a multi-state employer may have to have multiple policies or go with the lowest threshold policy. And those who are
Brian,
just in a single state.
So always you have to follow local laws, right? You never get to break the law because a local is different than a state, different than federal. But let's start out maybe in the narrowest scope here for a single location, single state employer that doesn't have local or state regulations on this. What are the two big federal laws that kind of govern this area of deducting wages and what's permissible?
Sure. So much of our discussion will be around the Fair Labor Standards Act, the FLSA, as we've touched upon in other conversations, because the FLSA does address when deductions or the amount of deductions that can be made. And there's also the Consumer Credit Protection Act, which Title III of that federal law governs how wage garnishments apply to employers. If some employers may have never seen that, some may, at some point have gotten a garnishment, and they look at it and they say, I have no idea what to do with this. And it's, as we'll get into, not something to throw out and just ignore. There are, requirements for employers there. But I think the best place to start is probably the FLSA, where, hopefully, our listeners are a little more, have some understanding and some background on that law.
And if they don't,
talk about deduction,
and if they don't, they need to, because it governs almost everything we do in payroll and human resources, right?
That's right. So if you're not, give Mike a call, give me a call, reach out to, Asure and have someone explain it to you. But when we talk about the FLSA, where, deductions work and have consequences in different ways for exempt employees and non-exempt. So we'll start with non-exempt employees because the FLSA really has not as much to say necessarily about deductions from non-exempt employees' pay. And again, as I mentioned before, non-exempt means, these are your hourly rate employees who are entitled to overtime. And generally, under the FLSA, it doesn't necessarily regulate what types of deductions can be made from wages. It more so limits, how much, deductions can be made. So, again, we're not considering state laws here. So, the main thing that the FLSA tells us about deducting anything from an hourly employee's wages is that generally deductions will be a violation of the FLSA if they bring the employee's hourly wage below the minimum wage. And so right now we're talking about $7.25 as the federal minimum wage. And so, that's something where, if an employee is being paid at that minimum wage and you're going to take an otherwise permissible deduction from that person's pay, let's say for, the cost of a meal, you're going to be limited if they're right at the minimum wage. So, if someone's paid $7.75, all right, then you have 50 cents per hour that you could deduct while keeping them above the minimum wage. But of course, if there's a minimum wage violation, if you go beyond that, federal law also. I mean, look, there's certain required deductions under federal law, such as payroll taxes and such. So, obviously employers must take out, those income tax withholdings from gross
Right.
pay. But, under the FLSA, there are a number of deductions that are actually, expressly permissible under the FLSA, such as, deductions covering the employer's, fair value or reasonable cost of lodging that's provided to an employee, or for meals that are provided to an employee. Again, in conjunction with the other federal law we'll discuss, the FLSA permits deductions, that are required by law, such as for tax or wage garnishments. And look, as will be a common topic, the FLSA permits deductions that are authorized by the employee. We'll discuss as we go in that, oftentimes what's, may be required is that a deduction is for the benefit of the employee. Not always the case. But, certainly, the FLSA for non-exempt employees, that's really it. We keep in mind the minimum wage issue. And other than that, it's not restricting employers from many deductions for those hourly rate employees.
So, Brian, I'm trying to resist going down a million rabbit holes here. FLSA is the federal level, right? So a lot of states and locals have minimum wages, $15 an hour in climbing. I'm assuming what you can or can't deduct and what dropping below that minimum wage threshold will just depend on your local regulations and how those minimum wage laws are written, different than the federal standard. Is that accurate?
Right, exactly. And so as we typically say, right, the FLSA, sets the floor, and, states can go above that. So, there may be some states that, say, you're not allowed to go below the state minimum wage with deductions, except in, certain circumstances. So, that's something that we'll often see. Don't just think, for instance, here, in New York, right, there are areas of the state that have a $15 minimum wage. So, employers, for example, should not assume that I'm paying $15 an hour to my employee. I can take all the deductions I want down to, $7.25 an hour because they'll still be making the federal minimum wage. That may be the case in some states, but, in others, you need to understand, what limit the state has on potentially going under their, higher minimum wage.
So, Brian, I'm going to break my own rule. I'm going to jump to a couple of use cases just because I want to clarify around this whole you can't go below the minimum wage. So, again, we'll give everybody the benefit of the doubt. As we assume no one on this is watching this show thinking, how can they squeeze the little man here? But how do they stay compliant? So if you're maybe you're running a cleaning business, some type of business that you need to supply a uniform, and just the nature of the industry and the thin margins you operate on. Maybe you are truly federal minimum wage employees, $7.25, and you want to set up a deduction so the employee pays for the uniform, the clothes, the shirt, the pants, the boots, safety boots, whatever it might be. Basically, any of that you do, the deductions cannot take them below that $7.25 minimum wage, correct?
Exactly. So, right, in the context of uniforms, right, any permissible deductions cannot reduce that employee's hourly rate under the minimum wage.
Now besides a payroll deduction, can you still, as an employer, require the employee to pay for, out of their own pocket, said uniform or safety boots or whatever the case may be?
So typically the answer will be no, because essentially, forcing the employee to pay for something that's required is tantamount to, a deduction itself. There may be situations where that's permissible. For instance, OSHA seems to state that, if, for instance, some safety or protective equipment is provided free of cost by the employer to the employee, and then that's lost or intentionally ruined by the employee, that under certain circumstances the employer could require the employee to pay for a replacement. But typically, the cost of the uniform, other than, for instance, casual, wear that, could be worn by the employee, outside of work. But, uniforms that are something other than that are typically, considered a business expense of the employer. And, if the employer requires the employee to bear any of that cost, we're talking about something that can't cut below their wages. Now, there are states that, treat this differently. For instance, in New York, there's a somewhat complicated way that the state goes about this. So for instance, we don't want to forget about cleaning. So, when there's the one issue of providing a uniform to employees, and then there's a second question of who's responsible for the laundering of that. And if it's the employee, are they getting paid for that? And different states will treat that differently. In New York, for example, more or less let's say you give an employee a polo shirt that has the company's logo. Well, even though they could wear that polo shirt outside of, business time, the fact that it has a logo on it makes it a uniform. So let's say, they have that uniform and now, they have 3 or 4 of those shirts and the employee needs to launder them. In New York, there's actually an allowance that employers are required to pay to employees in any work week in which the employee has to launder their uniform. And I won't get into the specifics for those New York employers out there, but it depends on the number of hours that week that the employee works. And of course, there's an option that employers can offer a free laundering service. But you can see that certainly the idea of a uniform doesn't necessarily end at, the company providing, say, a free of charge uniform. The company should consider, what time and expenses that employee might have with respect to, maintaining that uniform. And state law could dictate that the company needs to pay additional amounts above the minimum wage to cover that.
Brian, let me ask this. So, and it's a pretty wonky use case and example here, but I really just want to get an understanding of this. The fact that my deductions can't take someone below the minimum wage, and where I'm ultimately going here is over what period of time. So, for example, if I have a new hire, I might maybe they require a set of specialized tools, and I give them a toolbox filled with all these specialized tools. That if I did a deduction, a biweekly payroll, so I took out $10 per over for each of 26 pay periods in the year. It's $260 in equipment. Then I didn't take them below. But if I charged them the full $260 on their first paycheck, I took them below. What does the threshold look like to stay compliant here?
Yeah, so that's a great point. And what you brought up is a creative solution that is permissible under the FLSA in how to structure deductions from wages. And that, like you said, to avoid bringing the employee under the minimum wage in that 1 week by doing, a $260 deduction, right? Yeah, an employee can prorate the deductions and spread the cost of, a uniform or whatever, the cost is over a number of pay periods so that the wages aren't reduced. Now, the FLSA doesn't necessarily require this. Some states will. Even those that don't, I'd suggest that, when you're making a deduction, you're going to put something in writing to the employee to explain what it is. And, typically there's going to be something on payroll on their pay stub to show that. But, especially in the case where there's going to be, multiple deductions, over some time, that's something you want to put in writing to an employee, right? They shouldn't just be looking at their pay stub and seeing what that line item, deduction is for. That's something that should be communicated, at the time. For instance, the uniform is provided to the employee that, give them a notice saying, a deduction of X dollars will be made over X number of pay periods for a total deduction of, $20 per week or whatever that may be.
Yeah. Okay, so two laws. First one is FLSA. The major punchline is here, whatever you do for deductions, FLSA doesn't necessarily prevent you from doing deductions, but it says you cannot implement any type of deduction that takes someone below their calculated minimum wage, right? Is there anything about FLSA before we move on to CCPA?
So, yeah, I think under the FLSA, I just want to touch on, how it impacts and what it says about deductions for exempt employees.
Yeah.
So, generally, when we're talking about exempt employees for the purposes today, we'll focus on the white collar exemptions, right? The executive, administrative, and professional.
Give 15 seconds to recap for folks. Most know, but just in case, what is exempt versus not exempt?
Sure. So the general rule under the FLSA is that all employees are entitled to overtime at time and a half, their regular rate, when they work over 40 hours. Yeah. So those are your non-exempt employees. They are entitled to overtime. The exception to that rule is for exempt employees who meet certain tests, whether it's a duties test, a salary test, or other tests, that then if they meet those tests, the law typically says you can pay that an employee, a salary, and they're not entitled to overtime. So, that $1,000 per week salary covers, all the work they would do, and you don't pay them, anything extra depending on, the number of hours they work. So here we're talking about those exempt salaried employees now, and how, deductions will impact them. And this is actually something that, many employers are not aware of, that improper deductions to their exempt salaried employees can jeopardize the exemption, which means, an improper deduction here could result in that employee, in fact, being entitled to overtime pay, in addition to the salary you've already paid them. So, real quickly, and again, this is, we're not going to go through the whole FLSA here, but for our white collar exemptions, there's a duties test, then a salary level test, which, they need to be paid above a certain level. And there's a salary basis test, which is the most basic requirement. Is this person actually paid a salary? And so the impact of improper deductions means that, the law will consider they're not necessarily paid a salary and they're going to be paid overtime. So I won't go through these. Yeah. So, for instance, absences for personal reasons, right? So not a sickness or disability, just, I want a day off. I'm taking a day off. So, for exempt salaried individuals, the employer can only take full day deductions for absences from work. So, for instance, if an exempt employee, a salary employee, comes into work on Monday and, they don't feel well, they leave after an hour. The employer, if we're talking about an hourly employee, right, they would not be paid for the time that they were not working. But for an exempt employee, they worked that day, they get paid for the full day. You can't deduct a partial day's pay for this type of absence. And for most other deductions for absences under the FLSA, full day deductions are what's required. So that, really the flip side of that is what I'm trying to say is that if an employee shows up for work and then goes out, whether it's, an absence for sickness or a personal day, you can't make a deduction for their pay. So
I want to pause there because I think this is hugely important, right? Yeah. So if you're an employer, let's say you got 25 employees and you got a supervisor who is a salaried, and by all of the tests, they qualify as an exempt employee. They work probably 50 hours a week, but you don't pay overtime because it's a salary job. They make enough money, et cetera, et cetera. But if that supervisor extends lunch on Fridays an hour each day, and you're not happy about it, you maybe have even written them up and give them a warning saying, "Hey, you need to be back supervising the work and performing the tasks. You can't take an extra hour." You can't deduct that 1 hour because your behavior has now indicated you're really paying this person hourly, and if they complain and this ends up in a Department of Labor audit, you're going to be on the hook to pay overtime for that 50 hours, that extra 10 hours a week, going back possibly years, possibly for all people that work for you, even though they weren't complaining about the situation. I'm not overstating that, am I?
No, you're not. The consequences are really strict here in that, and again, there is a safe harbor provision I'll address, but yeah, improper deductions, for one employee, do not just impact that employee's exemption. If the employer is found to have an actual practice of making improper deductions from exempt employees' salaries, then the employer will lose it potentially entirely for everyone in that classification. Obviously, there are a number of factors. How often are the deductions being done? The amount. What's the time period when these are done? So there could be a defense if you have one rogue manager who's been doing this for a month or two, and you just figured it out and corrected it. Maybe that's limiting it enough, but. Again, the number of managers, right? If it's more than one manager doing it, that looks like a company policy as opposed to, one manager maybe just, getting it wrong. Right. So, yeah, we really need to be careful in taking deductions from our exempt employees. And I guess the other one I want to mention is even if it's a sick day, or a disability and the exempt employee is taking a full day off, that's fine. Again, we're talking full day increments, but the company must have a bona fide plan or policy that it's making the deduction in accordance with. So what does that really mean? That you should have a handbook. You should have a policy that provides for, what's going to happen when, an exempt employee is absent for various reasons, because then that's what's required by the FLSA in order to even make that full day deduction for a sick, someone being out sick, be legitimate and valid. Right. There are a number of other absences, types of deductions that can impact exempt employees. I'll just go through them real quick because it's difficult to get in everyone. But for instance, FMLA absences. This is one where it goes outside that rule of full day increments because for those who know that under the FMLA, employees can take intermittent FMLA leave, which means an employee could be out, take unpaid FMLA leave for 2 hours a week or 3 hours a day. Something maybe it's just to go to their appointment or dialysis, something like that, where they only need a few hours. In that case, under the FMLA protected leave, deductions of the proportional amount of pay can come out in less than full day increments. But other than that, we're really looking at other types of absences. You should presume it should be a full day increment and nothing less.
So if I can just kind of recap on FLSA, the two big components here that employers really need to understand: you cannot deduct wages. So FLSA does not prevent you from making deductions, whether it's for food, for equipment, for uniforms, for whatever the legitimate business reason is, so long as that deduction doesn't take them below minimum wage. But the gotcha number two is your behaviors, the way you set up deductions, can't treat that employee, an exempt employee, as though they are an hourly employee, because if you do, you may be blowing up your exemption status, and all of a sudden you're on the hook for overtime.
Exactly. Okay. And so look, the only saving grace here is that for exempt employees that, there's a safe harbor provision. But again, that basically means that you're going to have a safe harbor policy in your handbook, and you're going to, if there were improper deductions, you're going to immediately reimburse them. You're going to, have a complaint procedure and, basically comply with the law going forward. But, don't count on that good faith, getting you out of trouble. It's there, it's a defense. And so that means, if an employer, if you're hearing this today and you're saying I'm making a mistake, then, by all means, well, if you're making mistakes, maybe, speak to someone, legal counsel, someone at Asure, to discuss that. But addressing it quickly is the best case scenario if you have made mistakes.
Got it. Okay. So let's move on to the other law here, the CCPA. What the heck does that four-letter acronym stand for?
Right. Not quite a four-letter word here, but the Consumer Credit Protection Act addresses how employers handle wage garnishments. What's a wage garnishment? These are court orders for an employer to withhold money from an employee's paycheck for a number of reasons. Most often, the reasons are for debt owed on child support or student loan or other loan payments, and basically through this wage garnishment, it's a state or local document, so it'll take different forms, but it typically looks like a very official court document. And through that, the employer then becomes responsible for deducting certain amounts from the employee's wages and transmitting them to the creditor. And so, this federal law sets forth, certain things that an employer, must comply with. So, one of the first things the CCPA addresses is the garnishment amount. So typically, if you get one of these, wage garnishments, you'll see whether, the state counterpart might be different, but, it typically will specify the amount that needs to be taken out. And, typically it's under the CCPA, it sets a floor at, it can only be 25% of the employee's disposable earnings. Basically, that's 25% of their after-tax, paycheck, can be garnished, or they can only have wages that exceed, I believe it's 30 times the federal minimum wage. Only those that exceed, 30 times that can be garnished. So obviously what the law is doing is making sure that, employees are still making a living while, paying off the debt that they owe. Now, for child support and alimony payments, the caps are a bit higher. There's, clear reasons, I think, why that would be the case.
Sure.
And I mean, look, the caveat being, if you ever receive a wage garnishment and the employee comes to you and says, hey, I want you to withhold even more than the garnishment and pay that, right now, that's okay. I mean, obviously get that in writing, but employees can opt to, pay more, per week than is required.
I think you mentioned something, Brian, about FLSA that, so like a deduction, say for a uniform, it has to be agreed upon by the employee, but that's not necessarily the case for garnishments, right? I mean, you can't have someone that lost a civil case, the judge says, deduct this from their check, and the employee gets to opt out, right?
Right. So this is one where you're going to provide the employee notice, but it's not up to them. Clearly, I mean, to some extent, you could say this is for their benefit because the company is deducting and transmitting payments that are reducing their debt. But you can imagine, employees will not necessarily be so happy that, there's a wage garnishment, deducting part of their wages. So, yeah, certainly you cannot listen to the employee. The obligation here comes from the court, right? This is a court issued document. So remember that, trumps anything that the employee is going to tell you about it. And basically, the employer, you're bound to comply with the wage garnishment until you get a notice from the court telling you otherwise. So, the way this starts, you get the wage garnishment, And, at the time, once you receive it, you should let the employee know right away that this is what you received and that the company is going to, immediately begin garnishing wages. There might be waiting, for instance, New York, I think has a 10-day waiting period before wages can be garnished. So check with local law, but certainly it's something that, the employee should be notified of. And then, like I said, the employer keeps garnishing wages until it's told not to.
Brian, this is not
under federal law.
This is not complex, but it's yet another thing that employers have to do, right? You get these, you have to go set up the deduction in the payroll system. It's not that like it's hard, but it is a task. I can see where some employers may want to like charge an administrative fee. Are things like that legal?
Mike, yeah, we must be getting to know each other because you just asked me the question, which was the thing I was about to say.
Good.
So federal law does not address that. It doesn't, it leaves it up to the states. So, there are some states that allow employers to charge the employee an administrative fee for withholding, child support or other, garnished wages. The states will typically, if they allow this, they'll have a limit of the amount of administrative fee that can be charged. And to be clear, that if your state permits it, the deduction, that administrative fee is going to come out of the rest of the employee's wages. It's not coming out of the actual debt that's being garnished.
And just so everyone understands why, this isn't necessarily some mean employer try to run a company store and extract every penny out of their employees. There are real costs. It's not just the setting up of that deduction. You have to probably go through some accounts payable process. You're going to have to set up. So if you have multiple employees in a couple, 2-3 different states, you're going to have to set those states, right? Those treasury departments or child services or whatever those accounts are. You're going to have to cut checks to. Some might take electronic, some might require a paper check. You're going to have to minimum the cost of popping a check in the mail, let alone how many hours or minutes these tasks take from a finance department or a payroll department. So I don't want to diminish. I'm not advocating charging employees for this. It's probably 180 degrees from the kind of the culture conversations I think we like to have around building a productive workforce. But eyes wide open, there are real costs for employers setting up these, and not just setting up, but setting up and paying these deductions on behalf of that employee.
Yeah. No, you're exactly right. And I think that's one of the reasons why the anti-retaliation provision under federal law, only prohibits adverse action against an employee if they have a single wage garnishment. So you can imagine, if you have an employee that has 2 or 3 wage garnishments, this is becoming a problem for the employer to administratively deal with. While, I'm not, recommending, terminate the employee because of that. Under the federal law, you could, if they have multiple wage garnishments, without violating, the CCPA. Again, the better remedy might be if you're in a state that allows the administrative costs to be passed on to do that. But again, this is something that is one of those, costs of doing business. And this comes up from time to time. You'll receive one of these, and typically, you want to seek guidance on how to comply so that, you're, as the employer, you're not at risk of being penalized for, violating the wage garnishment.
Hey, Brian, looking at the clock here, let's kind of shift to just kind of a rapid fire if we can. There's a ton of use cases that I think we probably would be helpful if we brought clarity for employers. So I'm just going to rattle a bunch off. Sure. I got written down. So what about retail businesses? There's a shortage in the register. Somebody's till is off. Can you deduct that?
Correct. Yeah. So you can imagine, happens all the time. But most states require the employer to bear the cost of those losses that come from the cash shortages or damages or damage or stolen merchandise. Again, under federal law, not necessarily prohibited as long as the deduction doesn't bring them under the minimum wage. but most states prohibit it. There are a small number like, North Carolina and Missouri that may permit it, as long as it doesn't bring them below the minimum wage. But by and large, this is something where, look, unless the employee has, in connection with the shortage, been convicted of a crime, right? So it's thousands of dollars. You called the police, they're convicted of theft. All right, that type of deduction then might be permissible, but generally not. I can give you, in California, for example, no deductions for this type of issue unless the acted willfully in a grossly negligent manner. So then we're getting towards, it's not just a shortage; they likely stole it, right?
Right.
In Connecticut, no deduction unless the employee signed a certain form approved by the state DOL. And Maryland, requires the employee's written consent. That may be very hard to get in those situations.
Right. So the punchline, I think, for this one, state by state, you got to know your local regs. We obviously can help with that. But at a federal level, somebody's till is off by $3.17 because there's a math error or something happened. You really can't deduct it, right?
Right. Just the cost of business.
Next one. Let's take this one. How about just a simple payroll mistake? We accidentally overpaid you last pay period, so I'm going to take it out of your check to true things up this pay period.
Right. So federal law doesn't really address this. Again, we're looking to the states, but most states generally allow for deductions for overpayments. However, a lot of states have, certain requirements that need to be satisfied. Whether or not your state requires it, my advice would be to get it in writing, right? You want a written authorization that you can, deduct the amount of the overpayment, going forward. And, typically what we're going to document is, the date the overpayment happened, the total amount, and then the deductions, the amount of deduction going forward and for what time period. And typically you want to have a procedure, for the employee to dispute any deduction there. So that's what we're looking for, to get, the employee to authorize, future deductions. And like we said, most states allow this. They're just going to be requirements like in New York. There's a form of a written agreement that needs to be entered into. In Illinois, employers can do it, but only if it's done in the first paycheck following the overpayment. So generally, yes, but there are some restrictions on how an employer can do it.
And just the soft side of HR, just communicate with the employees the best you can. Some employees, they live paycheck to paycheck, right? No matter how much we pay them, for whatever their life circumstances are, no judgment, right? And they get overpaid one period, that money could be gone for like legitimate bills that we're stacking up, and shorting the next pay period might hurt them in ways that you might not even think of. So just communicate, obviously follow local in state law here. Next one. How about when an employee owes you a debt?
Sure. So my first rule here that I basically tell every employer is, you're an employer. Don't act as a bank. Typically, I don't like when employers get in the habit of, advancing money or making loans to employees. But you can under federal and state law, it can be permissible. So under federal law, there's a DOL opinion letter that says this might be one of those deductions for a company loan to an employee that it's permissible to go under the minimum wage. Again, there's an opinion letter on that. It's a little iffy, but again, we're also looking to state law. So most states, like I said, will allow employers to take deductions to repay a loan or advance. Again, how states treat it is a little different. New York, like our previous issue, requires a written agreement that addresses the timing, frequency, and duration of the deductions. Illinois, that they have a law that allows it, but caps the amount that can be deducted. And again, what I often see as a problem here is, what do you do if you make this loan and then the employee quits or you want to fire them? And then they're no longer your employee. And, unless you have you want a valid enforceable agreement, because depending on the amount, you may really have to go to, small claims court or, a higher level court to recover this. And so that's often not where employers want to be. So, again, depending on state law, you can work that into the agreement, what will happen, in terms of the last paycheck. But again, my general advice on this is don't become a bank to your employees, and especially because there are other issues, right? Think of discrimination issues. If you're only offering some employees advances and not others, and maybe you've offered it to someone of a male but not a female, or someone of a certain race and not of others, you're going to have to apply this loan or advance payment policy consistently. So that's another problem that can arise in these situations.
Got it. How about pre-employment? So maybe it's a drug test. Maybe they have to pass a math test. Maybe they have to pass some type of certification to prove that they actually have the skills to perform the job. Can you charge back for the cost of administering those tests or exams?
Right. So these are, again, typically handled under state law, but what most states consider is that these type of examinations are for the benefit or the convenience of the employer, and therefore, employers typically cannot require the employees to pay for these types of examinations, including background checks. For instance, in California, California prohibits employers from requiring any applicant to pay a fee that would cover a background check. In Washington, D.C., there's a statute that requires the employer to pay the criminal background check. But employers are not precluded from seeking voluntary reimbursement from the applicant. We won't go down that rabbit hole. But then there are other states such as Iowa, Minnesota that strictly require the employer to pay for criminal background checks. So typically these types of pre-employment exams or checks are going to be the responsibility of the employer. Again, it's for their benefit, not necessarily.
I know the answer to this next one, but this is too important not to ask it. Employer portion of taxes.
Yeah, so you're talking about the payroll portion, payroll, employer taxes. Yeah, those have to be paid by the employer. I think we're getting into a lot of serious violations, tax consequences and wage and hour as well, if you're trying to get employees to pay for what should be the company.
We have just expanded beyond CCPA and FLSA. We got the IRS and a whole bunch of other folks involved. If you're going to try to get your employees to pay the employer portion of payroll taxes, that's a no. Don't do it.
That's right.
We talked about uniforms, but it was maybe a context of how not to back out and so much that you dip below the minimum wage threshold for FLSA. Guide people listening today to how they should be thinking about what's the proper way to set up deductions for uniforms.
Yeah. I'm a broken record here, but it's going to, uniforms are really going to be dictated by state law. And I use, New York as an example, before. And look, these are things where, if you're going outside of requiring employees to, wear, basic, street clothes, then it's going to be considered a uniform. And, we have to consider, minimally the minimum wage and not bringing employees, under that. And then, again, it's very important to not just think that providing a uniform is the end of it. There may be, situations where, like I mentioned under New York law, that, the laundering of uniforms is addressed by state law. And if it is, you need to make sure you comply with that because, here in New York, it's a tricky area. And I've seen numerous class actions where, an employer gave free uniforms to employees. So they didn't have an issue there, right? They provided uniforms free of charge. So no deductions. But then the company, does not launder the uniforms or does not provide a sufficient laundering service. And in those cases, it's a class action. It's applying to everyone who had this uniform. And they are going to say they were entitled to a uniform allowance. In New York State, employers typically have to pay up to, I believe it might be even close to $10 or more per week, depending on the hours that an employee works in, uniform maintenance pay. So there are other states that require that. So, again, look to your law. Again, we want to make sure, we're not having issues with the minimum wage. And also, don't forget the laundering portion of having a uniform.
So we've covered tools and equipment. I think that falls into the same buckets as uniforms. Anything else you'd want to give guidance on child support?
I think we really hit on that. Again, you're going to be subject to, the wage garnishment. Pay attention to that. Don't ignore it. Sometimes they're served by a sheriff or it might just be mailed. But, that's something where, take it seriously. Don't wait for multiple notices to come. It's something that has been resolved in the courts. And now, you're being not just asked, you're being ordered to do something. So understand it's illegal.
Give some guidance here for validating. I know a business owner that literally this is about a year and a half ago. Someone walked in the door, handed a piece of paper, and it turned out to be a server. Right? It wasn't a sheriff. It wasn't some official piece of mail that looked like it came from Secretary of State. It was a server, process server. And handed it to a front desk clerk of this business, and the owner thought it was a scam. She ignored it. She threw the paper away, and there was a legal judgment on one of her employees, great employee, but she ended up not being compliant with the order in setting up the deduction. What's your advice for employers to vet this and know whether it's real or not?
Yeah, and look, I've had numerous clients, call me and email me, something. They're saying, we don't even know what this is. Tell us what it is. And I go through with them. And I think oftentimes these wage garnishments, they consider that an employer is going to receive this and know nothing about it. So what you'll often see is that, there's going to be, a website link or a phone number to someone to call to ask questions, or there's going to be typically something on that wage garnishment that would provide you additional information. Further, there's often going to be a reference to the case or the case number or the caption of the underlying legal action. And so, maybe a lay person may not know how to go find that, but, speak to, you can seek legal counsel who can take a look at it and, reach out to that court or look up online and find that case. So yes, these sometimes they look like a foreign document that we really don't know if it's legitimate or not, but typically there will be information in there that can allow you to figure out the legitimacy, and if you can't, then probably seek legal counsel to do so.
Yeah, and to be clear, if you as an employer are given a court order, you're on the hook. This isn't whether your employee agrees to this deduction or not. You are the responsible party, and you could be in legal hot water if you don't comply with this order, right?
Oh, absolutely. If it's been established that the company's been served with the garnishment and has ignored it, there can be repercussions, penalties, often depending on state law. But yeah, there can certainly be penalties because you can imagine, the situation where, maybe there is ill intent, that an employer doesn't garnish wages because they like the employee. And, no one's going to just assume that you as the employer, threw it out or didn't know what you're doing. It's a legal document. You're going to get served in a proper way, whether, like you said, through a process server or otherwise. And, it should be taken seriously. Right. Certainly there are financial repercussions if you don't.
Couple more use cases I want to walk through. So breakage. I'm working on a piece of machinery, and maybe it was wear and tear, in my opinion. Maybe the business owner thinks it was improper use of the equipment. Something breaks. If the machine breaks while I'm using it, can the employer deduct my wages to pay for that?
No, typically not. This is going to go, probably, similar to when we talked about register shortages, that, this is something that is the employer's responsibility. It's a cost of business, unless, with the caveat that, look, if you have evidence of an employee intentionally, right, damaging company property, and you can establish that, then you might actually have a legal issue there on your hands and can get, compensation. But yeah, typically within, the framework of their employment, acting, prudently, well, you're not going to be able to deduct for breakage. And yeah, that's an area where I've seen a lot of employers get, in trouble, whether, sometimes it's even just the threat of that leads employees to, complain and take legal action, right, even before there's an actual deduction for that. So, be very careful with breakage. Typically, we're not allowed to do that.
You got a construction worker, they're on top of the roof. They say, screw this job. I hate it. I hate you. They throw their pneumatic nailer off the roof. Criminal action, probably safe to deduct. But that nailer who's on, the construction worker's on top, and they accidentally drop their pneumatic nailer 2 stories and it breaks. Cost of doing business, you can't make the deduction, right?
Correct. Yeah.
Okay. Couple more I want to hit.
Sure.
Contribution to a charity, right? So, hey, instead of passing the hat around the cafeteria, it's, hey, would you like me to just set this up as a payroll deduction for you? I can imagine all kinds of weird areas this could go around perceived coercion and, hey, what if it takes them below minimum wage, but they were the ones they volunteered it, they wanted to make this deduction. Give us some guidance in the area of charitable contributions.
Yeah, so typically these are, an employer is free to set up the ability to make charitable contributions through payroll deductions. It's generally okay. Unlike some other, for instance, there's a provision that allows, some payment of other, things pre-tax. This is going to be a post-tax payment. But yeah, a company can set this up. They can, what I typically advise that if a company is going to do this, that, they'll work with one or more charities and, they'll have something in writing, more or less a brochure that can be provided to employees that can spell out, the rules for, how, these are often called, right, workplace giving programs, spelling out the rules of how to do that, how to enroll, how to make the deductions. And look, these are generally, right, there's always that concern that, there's going to be, right, coercion or, this isn't truly voluntary. We need to be very careful about that to make sure it's clearly a voluntary thing to do. But other than that, this goes hand in hand with, setting a culture. And, so some companies feel that, this helps promote, a positive, inclusive culture by, allowing employees to conveniently, make deductions that can go to charities. So, yeah, absolutely.
Yeah. Brad, I got one more, and I think we'll call it. There's a bunch more use cases, but I think we hit on all the big ones here. The last one is maybe employee purchases. So maybe I'm a a person, I'm bringing in a second income, maybe to the house, and I'm working at this retail facility. I'm working at this, maybe it's a hair salon, and most of my income I spend on buying products because I get them at a company discount or something. So my net paycheck might go below minimum wage, but that's okay with me. I'm actually working there for the discount, or I'm thinking a retiree working for free golf or something at that, right? Speak to services received, gym memberships, maybe it's actual products received from quote unquote the company store. That term obviously has some negative connotation to it, but what's your guidance for employers when it comes to payroll deductions for products and services
we
purchased
can see that,
by the employee?
So, the deduction here is going to be, for the benefit of the employee. That's clear. But at the same time, you can see how we could easily get into, minimum wage issues. So, my typical advice when it comes to, the employee purchasing things, whether it's, like you said, product or, maybe even uniforms, right? They're provided 3 free uniforms, but you can purchase more if you like. Things like that. I like to have that done as a separate transaction where, the employee pays the employer. You can provide the discount that way. But that, when you do it through a deduction, there are a number of things that you're risking. I mean, number one is, is this allowable under the particular state law? Because I think under federal law, probably allowable, provided the minimum wage, we don't violate minimum wage issue. But, there could be, state restrictions on this. But, regardless, a lot of times it's going to result in a minimum wage issue because of the cost of these things that are being purchased. And so, I think just as a general rule, if the employee is purchasing, their own product, that it shouldn't be done through deductions. It should be a separate transaction, apart from that, just to make it cleaner and avoid any potential issues.
I think that's really good advice. And just maybe the thing I would coach folks on, that employee who is a good, loyal, friendly employee today, you got a great relationship today. They're buying your company's products or services as a payroll deduction with no issue until it's an issue, right? And so things might, just because things are going smoothly doing this today, who knows what life events in your life, in the survival of your business, life events for that employee, that things can turn, things could change, and that person could feel very differently. And all of a sudden you have a tenuous relationship a year or 3 years down the road, and all of a sudden they're like, wait a minute, I haven't been receiving minimum wage for the last 3 years. And what was a happy employee 3 years later ends in a not so good way. And all of a sudden, boom, you're exposed retroactively to a wage and hour audit. So best to
Mike, and I think that wraps it up perfectly. I think at the beginning we talked about, doing deductions out of, some, ill intent sometimes. And here, as you just pointed out, even if an employee is saying, yes, do this deduction, I consent, you need to be aware that sometimes, the law requires more than that employee's authorization. It might be just a prohibited deduction, or, there are other hoops you have to jump through. So, I think that's a great point. Don't assume that because an employee today is saying, make the deduction, that number one, they're going to be okay with that, 3 months from now. And number two, that the federal or state law actually permits
it. I think it's a perfect place to end, Brian. If there's anything we can do to help, Asure provides fractional outsourced human resources services to clients, pennies on the dollar for what you could ever hire an in-house HR staff to help build the employee handbooks, the training, the guidance to keep you in line and keep you compliant, to keep you out of hot water in the first place. But when troubles do arise, that's where Brian's expertise comes in as well. There'll be a survey that pops up at the end of this event if you'd like us to reach out and see if there's something we can assist you with. Brian, I learn something new every time I talk to you. I really appreciate your expertise on this topic, and I'm sure our audience does too. So thanks for coming today.